One more go. Welcome, everyone. My name is Andrea McAvoy, and I'm the Director of Client Services here at the Office of Intellectual Property and Industry Research Alliances at UC Berkeley. Thank you for attending today's first Talking Outside Consulting, Conflict of Interest, and Patent Acknowledgement session. IPIRA offers a variety of webinars throughout the fall and spring focused on licensing and patenting, industry research funding, and SBIR, STTR funding. We will be introducing a new topic next spring called Working with Companies, Fundamentals for Graduate Students and Postdocs. More information will be put into the chat, so you can register now for these events. Also, if you create or manage research data in your work, you may be interested in free webinars that are offered by the Berkeley Research Data Portal. You'll see a link for these webinars in the chat too. Today, we have the pleasure of hearing from Laleh Shayesteh, who is IPIRA's Director of Intellectual Property and Administration. Also joining us are Mike Cohen, Director of Innovation Ecosystem Development, Deborah Summers, the Director of Marketing and Communications, and Eric Geigerich, who is the Director of our Industry Alliances Office, should be joining us midway through this webinar. We are recording today's webinar. Feel free to type your questions in the chat as we go along or unmute yourself to ask questions. Laleh's style is very interactive, so feel free to ask questions anytime. And let's see, our IPIRA contact information will be provided at the end of this webinar. And also, just to give you a heads up, we're going to do a poll in a minute that would just allow us to know who's in the audience today. And that there is a post-event survey at the end when you sign off. We greatly appreciate your filling that out because it really helps us identify topics that you might be interested in hearing from IPIRA on. So with that said, why don't I launch the poll? I'm thinking you're seeing it. Yep, great. So we'll give you a minute or two to fill that out. Okay, I keep on going. I'll shut it down in about 10 seconds. All right, there you go. And there's the result of today's poll. And with that said, Laleh, the floor is yours.
And before we get started, Andrea, can I ask, are we recording today?
Yes, I thought I hit that.
Yeah. Okay. Yeah, you did.
Great. Okay, cool.
Awesome. Hi, everyone. Thank you for coming to this meeting. I see that a bunch of us are faculty members at grad students, so that's awesome. I will be talking about consulting agreements and, you know, the bells and whistles that go with it. For example, including guidelines and also considerations such as conflict of interest, and also remembering that hopefully all of you and all of us have done the patent acknowledgement, how consulting might be with, you know, how consulting might work with patent acknowledgement. I do not talk from a PowerPoint, so I like it to be interactive. So please, as I speak, bring your questions to the floor. This way we can all learn from each other. One of the largest number of questions, right, that we receive in our office, at least I receive in our office from new faculty, from postdocs, from grad students, is, can I consult? Right? And then after can I consult is, okay, I have been given this document to sign. What do I do with it? Right? So, and that's exactly the reason why we are having this conversation today. We thought it would be really good for all of us to get the basics down and then go from there. So why consult? Why would people ask you to consult for them? Well, because companies desire and like your knowledge and skills. You are here at, you are at Berkeley, everybody, and because you do really interesting research, right? Breakneck research, everybody is interested. And a lot of the companies that come out of UC are startups out of UC, which then again have the desire to have the faculty member either as a founder or as a consultant or both. So is consulting okay with UC? Absolutely. UC actually encourages consulting, no problem. There is a time limit for consulting if you are on a 9-month cycle. If you're a faculty member or, if you're a faculty member on a 9-month cycle, you get to have 39 days of consulting per year. If you're on a financial year cycle, so an 11-month cycle, you get 48 days. You are allowed to have 48 days of consulting per year. And this is important because you do not, if you exceed those days, then you might be under a conflict of commitment. You are an employee of UC, so you need to make sure that your employment for UC reigns supreme. Right? You do not go over the allotted amount of time for consulting. So after that, then. Are there any guidelines, on consulting for UC? As a matter of fact, there are. They're both on our IPIRA website and on our sponsored project office website. There are guidelines. I just posted the one for IPIRA, and maybe Deborah will help us with this one. But both sites have guidelines for consulting. Now, I will go through with really broad brush strokes on the to-dos and not to-dos of these and what to consider for when you're going for consulting. But if you need any further information, you're always welcome to reach out to me, but also you're also welcome to reach out to and review these pages, both on the IPIRA website and on the Sponsored Project Office's website. Let's see. So what to consider? For the first consideration, I brought up that the number of days, right? So if you're asked to do a consulting with a company, make sure, hopefully, that the number of days you'll be consulting with them will not conflict with your UC employment. So you do not want to go over the number of allotted days. The second thing, which is what I always tell the potential consultants, is to please be transparent from the get-go. Let them know that you are currently employed by UC and what obligations you have under your current employment with UC. Those are both really, really important. The company may or may not know, but as long as you're transparent with them, that's really important. For example, that the IP requirements, the patent acknowledgement that you signed with UC, the IP requirements always win over whatever they ask of you as far as IP is concerned. But I will go through that right now. Because when you are about to do a consulting agreement, you are going to be asked to sign a consulting agreement. The first consideration and a reminder is that consulting agreements are personal agreements with you. They're not agreements with the university. So be careful with that. You are signing on behalf of yourself, not on behalf of university. So a lot of the protections that are given to you from the university no longer exist. So you're basically on your own when you're dealing with these consulting agreements. And that's why we are going over these considerations. Under consulting agreements, you may likely be asked to receive confidential information of the company. So you want to make sure that the confidential information that you're going to be receiving will not be conflicting with what you're doing right now, and be really mindful of what you want to receive and the extent to which you want to receive. And why is that? Because it might conflict with your current work, right? If they say you're going to receive, for example, if the company says you're going to receive confidential information, and then you're not to use or think about or work on this confidential information ever, or at least for a very long period of time, it might actually conflict with your current work. And you also don't want to mix, even if it is by chance, the consulting projects and your UC projects accidentally, right? And the way to skirt around this and be careful about this is to have a very clear statement of work with the company. What is it that you're going to do with the company? Even if you do receive confidential information, it needs to be very separate from what you're doing with the university. That way, you will always have that, like my SOW, my statement of work with the company is ABC, but this is what I'm doing for the university, right? XYZ. That way, you're careful, and the company will also understand that you're diligent and careful too. Then the other reason why this is really important to have, why it is really important to have a clear statement of work with the company is because you don't want to jeopardize your future funding, right? If the work with the company and the work at university get mixed up with each other, even if accidentally, this could jeopardize your future funding. You don't want that, right? All right. The next one, actually, before I go any further, do I have any questions? Wow, I'm that clear. Okay. This is not a very, very long talk, so you guys should ask questions if you have them. All right. The next consideration is assignment of IP. You will always be asked to assign IP. So you will be asked in this consulting agreement to assign any inventions or other forms of intellectual property that you create while you are doing a project for the company to the company, right? But what you need to do, and this is what we have always suggested, is to make sure that that assignment of IP, assignment of intellectual property, is always subject to your current obligations to the university. You are obligated, when you entered into the universities, just like I did, we all signed a patent acknowledgement agreement that says any IP, any patents, inventions, or other pieces of intellectual property that we create while we are working at the university, using university resources, using university funding, will belong to the university. So this could create a conflict between the work that you're doing with the university, right, and the work that you may be doing with the entity as a consultant. And this is the one point that the entities will always have a heart attack on. I mean, 100% of the time, when you say, okay, I will assign to you subject to my agreement, my prior assignment to the university, the companies will have a heart attack. So the thing to do with there would be, number one, you're always welcome to send them to us, and we will explain to them that the work that you do for the company, so long as it had nothing to do with the university, it had nothing to do with the university work, did not use university facilities or resources, can belong to the company. That's fine. And to do that, to make sure that the company is clear on that piece of IP, if you have actually created an invention while you were employed while you were consulting with the company, you can always request a disclaimer of an invention disclaimer request form. And let me see, maybe Deborah can help, yeah, post it for us. Basically, that disclaimer form asks for a very, very brief invention disclosure to the university. We don't want to know in excruciating detail what you have done, but broad brush strokes so we understand what it is you have done. One of us, there's 5 of me in the office, one of us will pick it up. We will take it to your department and we will let the department know that the inventor believes and we agree that this invention was not done using university resources, university facilities. Department, would you please sign off and allow us to disclaim this invention? Basically say, we have no interest in this invention. Go ahead, company, you can have it. And inventor, this belongs to you and the company. It will not belong to UC. Companies are always happy when they receive that because it creates a clear chain of title for the company. All right, let's see. Like to another UC does not count against the maximum annual consulting days. What needs to be submitted? Any restrictions? So, Christina, are you asking how consulting to another UC does not count against maximum annual? So as far as I know, all of us are so all 10 UC campuses we all are under the regents, right? We are all under UC regents. We have already provided all of our IP to the regents. Also, Christina, maybe you can elaborate a little bit on what you mean by consulting with another UC, because usually we collaborate with each other. We don't consult with each other. Is that correct?
I know that there are some exceptions to inter-UC collaboration versus consulting. I do know that there is an exception where there's certain types of consulting that does not need to be counted against, I think it's 40 days a year or whatever the day limit is. And so I was wondering if you could talk a little bit more about that of, what is included, what is not included, and then anything to look out for regarding that.
I will look into this one further. Maybe if Mike or Terry know more about this, but to the extent that I know and all the questions that I've received to date, they have to do for consulting for outside entities, not within UC. And for outside entities, the number of consulting days are 39 days if you are on a 9-month cycle, or 48 days if you are on a yearly cycle, fiscal year cycle, meaning 11 months.
I agree. I have not seen that kind of consulting within UC campuses. Now, maybe there might be a situation with staff that have special projects that might be considered consulting, but even that, that seems odd.
Yeah.
It's not specifically with other UCs. I just gave that example of that, of what I've heard, but I know that there are some exceptions to the maximum consulting days that you do, like you're able to submit something and it doesn't count against to it. And I don't know the criteria for it. So that's why I was asking about it.
This is Terry. I don't have any information that could help that. I see the same kinds of consulting agreements that Laleh does, and what the departments might agree to beyond that, I just don't have any information on.
So the one thing that I do know is, and I was going to bring it up towards the end of the conversation, is that as part of if you're interested in consulting, for anybody who's interested in consulting, you do have to fill out 2 different forms, right? One of them is a consulting form you have, and the other with the university, and the other one is a conflict of interest form, especially if you're consulting for a specific company, just to make sure that, for example, you're not receiving or even especially if you're receiving different forms of compensation, such as equity in the company, right? So you need to fill out the conflict of interest and also the consulting form. Under that consulting form, perhaps if you want to have a different schedule for consulting or seek exceptions, that will be between you and your department. That's not something that comes through us. Is that helpful, Christina?
Yes, thank you.
Okay, awesome. Okay, so that was for assignment of IP. All right, and then the other considerations, the last two considerations that I know of that I have seen are when you're asked to sign a consulting agreement, a lot of entities ask for you to be liable or to take on insurance for liability, which I have always thought would be a little bit silly and crazy as a consultant, because as a consultant, you are providing information and help to the company. You would have, as far as I know, no idea how that information is going to ultimately be used by the company, right? So if you were to sign the consulting agreement and are being asked for these odd liabilities, so for example, you are going to pay for all of their counsel costs if they have been sued by a third party, I would say no to that, and I would only limit that to possibly if you provided information negligently. But other than that, not at all. You should not be carrying on any liability. And the last one that I've seen that I suggest you be carefully looking at would be a choice of law. And what do I mean by that, right? A lot of companies might say, for example, remember, and assuming that we are all California-based, right? The company will say that everything under this agreement is going to be according to laws of California. That's perfectly fine. But let's say that you want to now consult for a British company, and it says that it is all going to be under British law, and if we get into a fight with each other, we are going to go, to a court in England. Well, you don't want that, do you? Right? So it will be really good to be careful and always limit that choice of law, and try to make sure that you don't end up in a country where you don't want to be, as far as wanting to fight. So limit to California, or just be, for example, silent on them. The last point that I had is, as I noted before, UC needs for you to disclose your conflict of interest with the university on a yearly basis, and also disclose all of your consulting activities. So if you're consulting, please make sure that you do fill out your disclosure forms regarding consulting. Finally, what is the role of OTL in all of this, right? We do receive a lot of questions for guidance. And what I have always suggested is if you have a consulting agreement, it's like 50 pages, 60 pages, or however long it is. Some of them are really, really long, right? Some of them are nice and short, but a lot of them are extraordinarily long. I am always happy to review them, but as a friend, but not as a UC representative. I'm always happy to let you know what I think is wrong with the agreement, what you should consider, what you should request for alterations, but hoping that we will all understand that this is just as a suggestion and not helping you as a UC representative, because coming full circle, I noted that these agreements are agreements that are personal to you. They have nothing to do with the university. And with that, I'm done. So do you have any questions?
Hey, Laleh, did you address the UC patent acknowledgement? Because I forgot to in the beginning of the webinar.
Yeah, you did, and I did too. Yes.
Oh,
So,
okay.
yeah. So that all of your agreements, especially granting IP rights, are subject to your prior granting of rights as part of your employments to UC. So under the patent acknowledgement agreement, all of us have filled out that agreement, and I think unless you're brand new as of July, you have signed the former patent acknowledgement form, which was a one-page document. Now it's a two-paragraph document.
Well, I have a comment that might be kind of color commentary that might be informative for the group. Sometimes, as part of your relationship with an outside company, there might be a consulting opportunity, but there also might be a collaborative research opportunity. And our office and the IAO, the Industry Alliances Office, can help with that, especially, for example, in deciding what kind of work relationship this is going to be. Is it going to be a formal collaborative sponsored research or independent consulting? They might require ask the faculty to sign a confidentiality agreement. And I'm pretty sure that IAO will help you with that, even though some people might consider that a agreement between you individually and the company. But just like with a consulting agreement, the confidentiality agreement has some conditions relative to the university and your research and your ability to publish.
Correct. Yeah. Yes. Thank you. Yeah.
Terry, do you want to chime in? Okay. I take
Sorry,
that
I'm still getting over my heart attack. So no, I don't have anything to add.
Okay. Does anyone have any questions? All right. I have to say that webpage looks excellent. So thank you for posting that, Deborah.
Yep.
Deborah, speaking of posting, is there still a web page that posts best practices for faculty consulting agreements?
Yes, there is, and there's a link to it on our the consulting page that Laleh posted earlier. I'll repost it right now.
Nice, thank you. Because I think, as Laleh said, we can't be your personal attorneys. But for example, that document that we did generically gives good best practices on how you can think about the consulting agreement. And you can even send that document to the company that you're consulting with and say, you know, here's some best practices. Everything should comply with that. And maybe they'll proactively include that compliance.
That's awesome. Yes.
Well, and Deborah will be sending out an email, within the next couple of days, having these links and resources that are available to you. So you get it here, and you can also find it in your inbox. So if there are no further questions, I'm going to post the contact information for a few of our members of our group. Deborah will also be posting this information to the chat. Please don't hesitate to reach out to anyone on the IPIRA team. And thank you again for attending and providing your feedback on today's session by completing our short survey. So
Thank you.
thanks. You're welcome.
Thank you. Of course.